Hi, everyone, and thank you for joining us for our webinar, Plan Your Future, What You Need to Know. My name is Anessa Kajtazovic, and I'm the Community Affairs Manager with the APBD Research Foundation. The foundation was launched over 20 years ago by three brothers, Gregory, Emil, and Michael Weiss, who wanted to help others who, like themselves, were impacted by APBD and to advance the research and development of treatments. We are the only US-based nonprofit patient advocacy and research organization dedicated to finding treatments for APBD and related GSD4 diseases while also improving the lives of those affected. Our mission is to improve diagnosis and care, support patients and families, raise awareness among healthcare professionals and the public, and help move promising research forward toward treatments. Today, we're grateful to be joined by Brad Frank, an attorney with Barnes & Thornburg, who has generously volunteered his time to speak with us. Brad focuses on estate planning and wealth transfer strategies, helping individuals and families plan for the future in thoughtful and meaningful ways. Now, Brad will walk us through the basics of estate planning.
Thank you, and thank you for having me here today. And I'm glad to be here for the APBD Research Foundation and to help the group talk about estate planning. What do I mean when I talk about estate planning? I think a lot of people think that, well, I don't have to do an estate plan. I just need a will. I just maybe need a trust. Those are all one and the same thing. And I think that's a common misunderstanding. And I think a lot of us, whether or not we may view ourselves as rich or wealthy, we still very much have and or need an estate plan. But when I talk about estate planning, what am I talking about? Well, first of all, there's the accumulation phase of estate planning, and that's sort of the work to create an estate for which you need to plan. A lot of us spend a lot more time in that part of the process, but I'm not going to talk today about anything related to investments or anything like that. There's also the wealth preservation part of estate planning, and oftentimes with clients, we end up talking about maybe nursing home planning or asset protection planning. Those are pretty specific and niche parts of the law. And if those are things that are of concern, you really should try and find counsel that can help you with those specific things, because there are a lot of rules which are constantly changing that you want to make sure you don't run afoul of. But again, I'm not really going to talk much about that today, other than to the extent taxes relate to wealth preservation. The two main things we're going to focus on today are the last two bullet points here, the distribution of assets and planning for incapacity. And when I talk about distribution of assets, we're going to talk a little bit about taxes and tax efficiency. We're going to talk about making that cost effective, which really has to do with probate. And we're going to talk about making sure everything's in line with your goals. And then also, certainly, incapacity planning has become a larger part of the estate planning conversation for most of our clients. What different types of an estate plan can somebody have? A lot of people who have never gone through the process of creating a will or creating a trust, they think, well, I don't have an estate plan. Well, I guess I'm sort of here to tell you, you effectively do, whether you realize it or not. And the first stop for that would be the third bullet here, actually, which is the law of your state of residency. So in all the various states, we have laws about what happens if somebody passes away and has not affirmatively decided what happens to their assets through one of these other structures I'm going to talk about. And so, for the most part, what it says is if you are married and you pass away, your assets go to your spouse. If you don't have a spouse, they go down to your kids, down to your grandkids. If there's nobody below you in your family tree, they would go actually up to your parents. And then if your parents aren't around, it will go to your siblings and then down through them to your nieces and nephews and then out to cousins. That is what are referred to as your heirs at law in most states. And that's also what's called the intestacy disposition. And most people are probably generally fine with that order of distribution, except it's not always cost effective or tax effective. Also, though, oftentimes when I'm talking about that with clients and we start talking about how assets could end up with your siblings, that's sometimes when people want to kind of figure out what their other options are. So the next step would be the way you hold title to your assets. And so anything that is owned jointly as joint tenants with rights of survivorship, that will pass right to the person to whom you've named. If you have assets with a beneficiary designation or a POD or TOD designation on them, those will pass as well without requiring a probate. But again, that may not be the most tax efficient way to pass your assets. And also, those assets that are passed in that manner will go outright to the named beneficiaries. And a lot of people would rather have some other controls over those assets. So the next step up would be your will. And a will, as most of us know, say, when I'm gone, here's where my assets are going. And here is who I'm naming as what's normally now called the personal representative. Formerly, it was referred to as the executor. Here's who I'm naming to administer that process. And so for a lot of people, that'll work just fine, but understanding that that may require a probate to get to the assets where you've set for them to go. But a will can incorporate all the kind of tax planning I'll talk briefly about in a few minutes as well. But then if you really want to avoid probate, which again, we'll focus on in a second here, the next step up from that would be a trust, a revocable trust, a living trust. And that is a document that works much like a will. It says, again, when I'm gone, here's where my assets are going, and here's who I've named to administer that process. Again, here that person is called the trustee. But if you properly title assets during your lifetime, you can accomplish all of that without a probate proceeding. There are also trusts used in estate planning in other ways. We'll hear a little bit about charitable trusts, and that can be, very important to help organizations like the APBDRF. And then also more and more you'll hear about donor advised funds, which are not technically trusts. They have some trust-like qualities, but they're not technically trust, but those have become commonly used in charitable planning and estate planning as well. So I talked a bit about probate a second ago, and if you watch commercials late, infomercials late at night, or if you are on the internet, you'll often hear about the evils of probate. So what is probate? It's an informal, normally, court process to retitle somebody's assets when they pass away. It really is there to make sure when somebody passes away that their creditors get a chance to get paid. And that people who have certain rights to assets get their chance to make sure their rights are protected. That being said, in the vast, vast majority of cases where there is a probate, there isn't really any creditor of note, and there aren't any disputes over the distribution of the assets. And so most people view it as really just a hassle and both a time lag and a cost for the administration of the estate. Now, again, if you're reading all these resources or watching these resources, you'll hear, "Oh my gosh, probate is the worst thing in the world. It's the end of the world." In some states, that's still closer to true. In many other states, it really isn't that big of an undertaking anymore. Here in Minnesota, for example, where I'm based, things that used to take a few months now take a few weeks, and a lot of that has to do with just the use of technology and electronic filing. And a lot of courts have gone permanently to Zoom for probate type hearings. And so things are much more efficient. In some other jurisdictions, namely the Sun Belt jurisdictions, as well as New York, where I know we have a lot of donors, they still are not great for probate purposes. The courts are very busy. And in the Sun Belt states, there are a lot of older population and therefore just many more probates to be administered. So you'll want to talk to an estate planning professional in your jurisdiction to find out how big a deal is it really if I want to avoid probate. So if I want to avoid probate, what do I do? the answer there is make sure your assets are titled the way they should be. Um, if you own an asset with somebody else, like I said before, jointly, that will pass outside of probate when you die. If you have something in the beneficiary designation, that also will pass outside of probate when you die. And then otherwise, you can use a revocable trust to hold title to your assets for distribution when you die, and that will avoid probate because it's deemed as though the trust owns it, not you. And so some people say, that sounds great. I want to avoid probate. Then you explain to them they're the one who then has to go about retitling all of their assets into their revocable trust to avoid the probate process. And once in a while, we'll hear people say, you know what, somebody else can do that work when I'm gone, and that'll be okay. Um, the Now turning to the slide that's on the screen, when we use beneficiary designations in particular to make a distribution of assets, as I said earlier, that will distribute those assets directly to the person who you name as the beneficiary. That's fine. In a lot of cases, it works perfectly well. But what if you have reasons that you want to um, give the assets for the benefit of the person, but you don't maybe want them to have outright access? Maybe they're really young. Maybe you're concerned about their decision making. Maybe you're concerned about creditors they might have. Maybe you're concerned about their marriage, right? You might want to make sure the assets kind of have a protective wrapper around them. And so oftentimes, you'll want to leave the assets in trust for their benefit. Now, this kind of trust can be created within a will, or it can be created within a revocable trust. Um, but it can be a really useful tool in estate planning. And then also, you think about the terms of the trust. Do I give it to them at a certain age? Do they have to show me that they've taken certain steps towards maturity? Those kinds of things. But then, the terms are important, but then also very important is who is the trustee who's making those decisions. So that's something you want to talk about. And then sort of laying behind all of this is, again, outright distributions may sound great, but they may not be the most efficient for tax purposes. So for all of us who are watching this, assuming you're US citizens or in the United States, we have a federal estate tax system that we should be paying attention to. Now, for the vast majority of us, it doesn't really matter anymore, or for right now, because we each have a $15 million exemption from federal estate tax. And right now, that is scheduled to continue increasing, probably to the tune of at least $1 million a year on a going forward basis. It's part of the tax law, right? So, as much of the tax law is, it's permanent until it isn't, right? And so we will see over time as that exemption changes. And then, as I said before, I'm in Minnesota, and there are still about 15 states in the country, Minnesota being one of them, that has our own state estate tax. New York is another one. And so here in Minnesota, for example, the threshold is much lower. It's only $3 million. And so a lot of Minnesotans have to much more actively do some estate tax planning in their will or their trust. And very similar to people in New York, the threshold is higher, but it's still well below the federal exemption. There are also some other parts of the estate tax world that many of the participants here today would maybe have heard about, and regardless are things you'll want to talk to an estate planning professional about as you go through this process, possibly. There's an unlimited marital deduction from estate tax. So anything you leave to your spouse is free of estate tax. And so if you live in a state that has just the federal estate tax, and your assets are below $30 million for today, the vast majority of people don't have to worry all that much about estate taxes if you live in a non-state estate tax state. But again, in those of us who do live in state estate tax states, you do need to do some sort of intelligent planning to use those exemptions and then rely on the marital deduction for the remainder of the tax avoidance, at least on the first death. There's also gifting that plays into all of this. As you can see in the last two boxes here, that federal exemption I've talked about, the $15 million, You can use that while you're alive to make gifts, if you want to make large gifts, or you can use it when you pass away to protect what's left in your estate from estate tax, or you can use some when you're alive and some when you pass away. But that only applies if you want to make large gifts. As a lot of people are aware, there is an annual exclusion from our gift tax system, and that is for today $19,000 of value to any given recipient. So for a lot of people, you can do all the gifting you want without ever really having to think all that much about the gift tax system or the estate tax system. But just be aware that if you want to make large gifts, there are ways to do it and kind of to take it off your tab with the federal government. So I've been talking about some large numbers, right? And so a lot of people think, well, I mean, come on, I'm nowhere near that. I'm never going to be anywhere near that. That may be true for the vast majority of Americans, again, as it relates to the federal exemption. Even in 2026, $15 million is still a lot of money, and $30 million is certainly still a lot of money for a married couple. But in the states where the threshold is much lower, you can get there pretty quickly, even up to $3 million here in Minnesota, or closer to 7 in New York, because essentially everything counts. Your house counts. If you own a business or a portion of business, that counts at fair market value. Your retirement accounts count in the calculation of your taxable estate. Now, understand that they have income tax benefits associated with them, but they still count on the estate tax side of the world. Your sort of non-qualified, your taxable investment accounts. If you own something in joint tenancy with another person, half the value is attributable to you for the most part. Here's another big one people don't realize: life insurance proceeds. If you own a life insurance policy and therefore you continue to have the right to name the beneficiary of the policy, even though you certainly will never benefit from the policy because it will not be paid until you pass away, the death benefit is deemed to count as part of your taxable estate because the government says, well, you got to decide who got it, so we're going to count it all against you. Your cars, your boats, your other toys, jewelry, antiques, artwork, all those kinds of things. And then also, a lot of people don't realize if you inherited an asset, if it comes right to you, even though you didn't pay tax on the way in, right, because of the way our system works, it counts. It belongs to you. And so it counts in the value if it's not in certain types of trusts for your benefit. And so, again, as I said, the state estate tax thresholds may seem still quite high to people, but as you can see, when you add up all these amounts, you can get there pretty quickly in most cases. So I've been talking a lot about the way people leave assets to other individuals and some of the tax planning also associated with that. There's certainly a large part of what we talk about with our clients, and certainly a large focus of what APBD Research Foundation does, which is working towards charitable giving. Now, there are charitable benefits, or I'm sorry, taxable benefits to charitable giving, as we'll hear about more in just a minute. And for a lot of our clients, we will talk about incorporating charitable planning into their estate plan for the tax benefits, which, as you can see here in the third bullet. But really, there's so much more to the charitable giving than that. There can be, very personal reasons for wanting to give. They're related to the loss of a loved one or support of a loved one. There can be just the cause or the mission of the organization itself, and then just a broader concern for community. And I think, or I know, that's why all of us are here today. And so I'm going to turn over to Art Glassman here in just a second. And Art is the reason I'm here today. Art's wife, Penny, who you'll hear more about in a second, was like a second mother to me. And I think the story of Art's support for the foundation will really, I think, help you understand more why some of the reasons people incorporate charitable planning into their estate planning.
In 2009, when we knew Penny had this fatal and incurable and difficult disease called APBD, we did some planning to make sure we'd maximize flexibility and minimize taxes so our daughters and I would have a good base to work with that we might not otherwise have financially. We arranged for some gifts to the girls, and Penny stopped being a fiduciary. A fiduciary is somebody who um, controls financial interests. And we felt like she felt like she mentally maybe was not making the best decisions anymore. So we made some changes at that point. When she died in 2015, well, we had taken out a pretty sizable insurance policy on her when we were much younger and had younger children. So as soon as I received it, I set up something called a charitable remainder trust, or CRT. And what you can do is that then you put your money, if you will, into this pot, and it's called a trust, a charitable remainder trust. And you can decide how much you're going to take out of the pot during your lifetime and how much you're going to leave in the pot for charitable purposes. So you can adjust the payouts. For example, um, you can say, pay me 4, 5, or 6% or whatever percentage on an annual basis out of the investments of the trust. And then you get that, and you do pay tax on that, income tax. But when you set it up, you get a deduction for a portion of the amount that you put into the CRT. And then at my death, um, the APBD will get what's left in the trust, which should be something around the amount that I put in, unless I decided to take way more out of the trust than it could earn, in which case my deduction would have been less, or a reasonable approximation of what it's going to earn, in which case I got a pretty good size income tax deduction. I used an organization called the Minneapolis Foundation as a trustee. You can use Fidelity, you can use Schwab, you can use any foundation with trustee services. You can use a broker. I liked the Minneapolis Foundation, and there are foundations in every large city in the country that, instead of just giving them the money and then investing it and doing the best you can, they will also talk to you about other charitable organizations and possibilities. They will help you work through some problems having to do with even your other money. So it's nice to have somebody who has some expertise in this area. So I'm fortunate that I had the policy. I didn't need 100% of it to live on. It's a good result for me, and it's a good result for the charitable organizations, in this case, the APBD. I'm not alone in my giving motivation. There are a lot of reasons to support the APD or other charitable organizations as you review or revise or create your estate plan. I'm going to now introduce Jeff Cooper, and he's going to tell us a little bit about his journey and how he came to support the APBD RF through his estate plan.
My name is Jeff Cooper. I was diagnosed with APBD about 8 years ago after the kind of lengthy medical odyssey that many of us with APBD first have to endure, where I was misdiagnosed and then undiagnosed and left undiagnosed for an extended period of time. Ever since I was diagnosed in 2018, I've been involved with the APBD Research Foundation through its support groups, through annual charitable giving. And when it came time to revise my will, I decided that it was important that the APBDRF be a part of the revised will as well. We live in an interesting time in terms of medical research. There are all kinds of new possibilities that are opening thanks to advances in medical technology, particularly in the genetic realm. And so there are prospects now for treatments for APBD that simply didn't exist if you go back a couple of decades. Research, of course, costs money, and the volume of people who have APBD and related conditions is sufficiently small that there's not a natural financial incentive for drug companies or others similarly situated to engage in research with regard to APBD. But we are entering some changing times, and we're entering times where it may be that it won't require a vast investment in order to provide results, either in the form of treatments or possibly something looking like a cure. And so it was important for me as I thought about my estate to provide support for the APBDRF as part of that estate. I had two principal goals in formulating my estate plan. The first was to take care of my two children, one of whom has special needs and so requires a little bit more care and advanced planning than would normally be the case. But the second was to provide for a mechanism that would let me have an ongoing impact in things that I care about, in particular, an ongoing impact in the area of APBD. And so when I formulated my will, after taking care of my children, my principal goal was to provide for charitable gifts, principally to the APBDRF. Now, that can be potentially a very easy thing to do. Brad and Art have talked about some of the more complicated mechanisms for providing gifts. But as an initial matter, it can be as simple as going to a resource like freewill.com, the use of which the APBDRF underwrites for those of us within the community. And creating an effective will through freewill.com takes somewhere in the area of 20 minutes. In my case, it took longer because one of the things that APBD has done, in my case, is to severely degrade my optic nerve. So I have trouble seeing. But beyond that, it really is a very simple mechanism that allows for the creation of an effective will, and one that can be used to benefit not just family members and others that we care about, but also the APBDRF. And that is what I chose to do when I created my will through freewill.com. I'm going to thank you for listening and turn things back over to Brad. Brad?
Thank you, Jeff and Art. That was both meaningful, touching, and I think really useful as well to point out the various ways, and certainly there are many others, to benefit charities, including APBDRF. I've talked a lot about wills and trusts and all that. The other key documents, as I noted earlier on, are what we would call the incapacity documents, which are your healthcare directive and your power of attorney. And the healthcare directive is, most people understand, and often is the document people have, even if they haven't done any of this other stuff, which is your chance to set out your healthcare wishes to be used if you cannot communicate those wishes to the medical providers. So first, I would note, importantly, we always talk about it as naming someone to make those decisions, but they're making your decisions, not their decisions. They are supposed to follow your wishes, not their own. That being said, I would not suggest naming someone who has sort of very different views on care and end-of-life type decisions. Power of attorney document is very useful when somebody needs assistance in managing their finances while they're alive. Maybe they're truly legally incapacitated or maybe just need some help. One misunderstanding about the way powers of attorney work in most states, though, is most people believe that I'm signing this thing today, but it doesn't work until I'm, quote, incapacitated. But actually, the way it works in the vast majority of states is I'm signing this and it works today. And it continues to work even if I'm incapacitated. So the nice thing about that conceptually is that we as lawyers don't have to go around proving people are incapacitated because the document works right away. But it's a very powerful document. We'll all read stories every year about the person who takes advantage of their next door neighbor or their aunt or whatever through a power of attorney. So, I just say that all to not to raise too much of an alarm, but to note that you should be mindful of who you name. Also, in most wills, it will give you an opportunity to distribute your tangible personal property, your jewelry, your collectibles, your artwork, your furniture, your things. What I would say there is we see plenty of families who have disputes about money, but money is fungible. Things aren't. And oftentimes, if you're concerned that family members are going to have a dispute over tangible property, they probably are going to have a dispute over that tangible property. And you can often help diffuse that situation through deciding who gets it directly rather than leaving it to them to decide. And then one last thing I'll note is we've been talking all about terms for wills and trusts that can say, I want this asset to go to this person, or even in your will, like Jeff noted, you could say, I want this asset to go to this charity. That's great. And, a lot of us spend a lot of time thinking about those decisions and distributions. But coming back to beneficiary designations and the way you hold title to assets, those control over and above whatever your will or your trust says. So you can spend hours and hours deciding I want, 0.3% of my estate to go here and 9% of my estate to go there and putting all of that in a will. But if your beneficiary designations, let's say on a taxable account, like, I think Art used the example of a Schwab account, right? If you have an account at Schwab that says 100% of this goes to this one child, that will happen no matter what your will says. So I think you need to work either on your own or with your advisors to make sure everything's lined up the way you want it to be. So, where do you go from here? I guess I'll start with the little quote bubble over on the side. As Jeff noted, the APBDRF underwrites the use of freewill.com, and you can go to that website you see up on the screen. And I think that's a wonderful offering by the foundation, but also just a great tool. And, as we all know, technology gets better and better in many areas, particularly in this area. And so it can be a super useful tool for the majority of people. So I'd recommend you at least check it out. If you feel like you need more advice, whether more unique situations or maybe more complex tax planning, certainly that is what estate planning lawyers do. And so you could and should reach out to yours or to one in your area. And then also, as I noted, you'll want to do a healthcare directive and a power of attorney. Again, those are quite simple documents. Usually you can find them quite easily online. And then if you have a financial advisor or if you're your own financial advisor, you want to make sure to, as we were talking about, line up the ownership of your assets and the beneficiary designations on your assets so that all the work you do that I was just describing actually is implemented if you're gone, and you don't essentially by mistake leave a completely different distribution of your assets.
Thank you so much, Brad. As we wrap up today's webinar, I extend my sincere thanks to Brad Frank for sharing such helpful and insightful information with our community. A very special thank you as well to Art Glassman and Jeff Cooper for sharing their personal inspiration for including the APBD Research Foundation in their estate plans. We are deeply grateful for your leadership and for the meaningful ways you continue to give back to our community. If you have any questions about our seminar, please don't hesitate to reach out. You are welcome to contact me or Brad directly. Our contact information is on the screen. Thank you again for taking the time to join us today and for being part of the APBD community.